Welcome to Talking Business, your straight-talking guide to dealing with corporate matters. Whether you are a private or public company, an owner-managed business or an entrepreneur, a director, company secretary or in-house counsel, this is the podcast for you. My name is Sophie Brooks and I'm a partner in our corporate team. I was a transactional lawyer for a number of years before becoming a professional support lawyer, which means I'm now responsible for know-how across our corporate team. Each month, I'll provide an update on the latest developments that matter to you, and we'll be joined by an expert to take a deep dive into a key corporate law topic. Hello everyone, welcome to our latest edition of Talking Business. So today we're going to look at a few things. We're going to look at how failing to get a class consent can have pretty disastrous consequences for a company and those involved with it. We're going to have a look at what organisations can do now to prepare for a potential new offence of failing to prevent fraud. But first up, we've got a case that has implications really for directors of parent companies, because the High Court held in this case that a director of a parent company had been so significantly involved in the day-to-day running of a subsidiary company of that parent that actually that person became what's called a de facto director of the subsidiary. So it's a useful reminder, really, of the importance of individual group companies, each having their own distinct corporate governance structure with clear and transparent decision-making procedures. So most companies will formally appoint one or more individuals to act as a director. And where that appointment's valid, then that person will be what's called a de jure director, a director in law. I apologise, by the way, for being a lawyer who's now using a bit of Latin, but this is the way that they're referred to. So we've got de jure directors, directors in law, the formally appointed, validly appointed directors. But then English law also recognises other categories of director, including what we call de facto directors or directors in fact. So de facto directors are people who have assumed responsibility to act as directors, but they haven't actually been validly appointed as such. So an important point here for those kind of people that could be caught as de facto directors is that the general statutory duties of directors set out in the Companies Act, they apply to de facto directors. And those people can be personally liable for breach of those duties in basically the same way as a formally appointed director. But obviously, de facto directors perhaps don't think that they are a director of the company, and therefore they might not be aware of the potential obligations and liabilities that they have. There's no sort of single test that we can use for identifying whether a person is a de facto director. But as was the case in this particular case that we're looking at the moment, the court will consider various different factors, including things like whether the individual was part of the company's corporate governance system at the highest level, and whether they carried out functions that really only a director could perform. So, as I say, in this case, which was called Aston Risk Management Limited versus Jones, the High Court had to consider, amongst other things, whether an individual who was director of a parent company was also a de facto director of its subsidiary company. So at all relevant times, the subsidiary had two officially appointed de jure directors. So we'll call them A and B. A was also a director of the parent company, along with the relevant individual that we are concerned with. So the shareholders of the parent company entered into a shareholders agreement setting out how the parent and the subsidiary companies would regulate their businesses. And the agreement required the subsidiary's business to be managed overall by the parent company, and it prevented the subsidiary's directors from taking certain decisions without the prior consent of the parent's board. So, although never officially appointed as a director of the subsidiary, the individual, who remember was a director of the parent company, played a significant part in the day to day affairs of the subsidiary, holding meetings, making decisions, conducting negotiations on behalf of that subsidiary. Now, a little while later, the subsidiary eventually entered administration and claims were brought against the individual for breach of his fiduciary duties as a de facto director of the subsidiary company. The individual argued that he was not a de facto director and that his actions in relation to the subsidiary weren't taken by him individually, but were actually indicative of him exercising oversight on behalf of the parent company, as in fact was envisaged by the shareholders' agreement. And remember, the individual was a de jure director of that parent. But the High Court rejected the individual's arguments and held that he had acted as a de facto director of the subsidiary. The court was satisfied that the role the individual had played in directing the affairs of the subsidiary was consistent with him being part of its corporate governance structure. If not, actually, the key and principal element of it, the court said. He'd also performed functions on behalf of the subsidiary that could really only properly be carried out by a director. So some of the key factors, things that were important for the judge, were that the individual had been acting individually and not as a director of the parent company when he made decisions and acted on behalf of the subsidiary. So, reasons why the judge reached that conclusion included that the individual was clearly the dominant personality who drove the required decisions, with A, the other, who remember was the other director of the parent, simply agreeing with anything that the individual wanted. And although the individual might have obtained A's formal agreement to certain actions, they couldn't really be categorized as actions of a properly functioning board. And then another key factor was the role that the individual played in the subsidiary. That was considered to be fundamental. And it wasn't confined to particular clearly identified decisions, but it extended to all kind of day-to-day decisions that were difficult to categorize as being decisions of the parent company's board as opposed to decisions of a director of the subsidiary. So, acting as a director, a de facto director, brings many uncertainties. The individual director may find themselves personally liable for losses suffered by the company, and they can also end up being disqualified from acting as a director in the future, if their particular actions merit that. And it's also, as well as being undesirable for the individual, it's also pretty undesirable for a company, really, to have de facto directors, because inevitably it's going to give rise to some confusion in relation to the company's decision making structure, who has authority effectively to bind the company. So, whether a person is acting as a de facto director is always going to turn on the specific facts of the case. And you're going to have to look, like I say, at the individual director concerned and the specific things that that person is doing. But there are some practical steps, I think, that companies can take, and indeed directors can take, to reduce the risk of this happening. So that would be things like ensuring that the relevant company's corporate governance system is clearly documented and that decisions are then made in compliance with that particular system. Just having a system isn't going to be sufficient if you don't actually ever bother following it. Then things like where decisions are going to be made at board level, then obviously they should be taken at properly constituted board meetings or otherwise in accordance with the company's articles. And those meetings should then be properly minuted. And then the involvement of a parent company representative in the day-to-day operational decisions of a subsidiary should be restricted, and a representative is less likely to be a de facto director if they have control, for example, in the form of consent or veto rights in relation to specified activities only and not sort of wider in relation to general business operations. So, a few things there for um, parent and subsidiary companies to think about, and in particular for directors to think about in terms of reducing their potential liability. Okay, so moving on, back in March of this year, the government published its second economic crime plan. So, this was a plan for 2023 to 2026, which set out a range of measures intended to reduce economic crime, but also at the same time protecting national security and supporting economic growth. And one of the government's key commitments in the plan was to introduce what was called a failure to prevent fraud offence to help tackle corporate criminal liability. And this commitment's already been actioned by the government introducing the new offence into the Economic Crime and Corporate Transparency Bill, which is currently making its way through the parliamentary legislative process. So the government said in its plan that it recognises that the threat from economic crime in the UK continues to grow, with potentially more than £100 billion laundered every year through the UK or through UK corporate structures. And apparently, fraud accounted for almost half of all crime experienced by adults in the 12 months up to September 2022. So the plan sets out the government's strategy to meet these particular challenges whilst focusing more directly on impact and outcomes. So in particular, some of the key proposals in the plan include things like reducing money laundering by limiting the misuse of corporate structures, by implementing the Companies House reforms, which have already been proposed in the bill, and by improving the anti-money laundering supervision of regulated businesses. And there's also going to be greater investment in technology and investigative resources to help detect money laundering and then, having detected it, to help recover the criminal assets. Then another key proposal in the plan is combating criminal use of crypto assets, which is obviously a highly developing and growing area. So the government wants to increase regulation on crypto asset activities for the protection of consumers and businesses, and it's also going to establish a multi-agency crypto cell to identify and seize illicit crypto assets. And then finally, the government's going to reform corporate criminal liability by introducing this new failure to prevent fraud offence. So, as I said, the offence has already been introduced into the draft legislation. It's not come into effect yet, but the wording and legislation around the offence is there by this amendment to the Economic Crime and Corporate Transparency Bill. And I think it does represent quite a significant development in the fight against uh, corporate criminal activity. And in fact, what it's going to do is bring the law on fraud in line with the law on bribery under the Bribery Act 2010, which I think businesses are largely familiar with and up to speed with now. So, as the draft legislation is currently worded, then a large corporate body or partnership will automatically be liable if any of its employees or agents commits a specified fraud offence for the relevant body's benefit, and that relevant body did not have reasonable fraud prevention procedures in place. So I mentioned that it only applies to large corporate bodies or partnerships. So what does that mean? So an organisation will be large and therefore caught by the offence if it meets at least two of the following three criteria in the relevant financial year. So those three criteria are having more than 250 employees, having a turnover of more than £36 million, or having total assets of more than £18 million. So if you satisfy two of those three criteria in relation to employees' turnover and total assets, then your organisation will be classed as large and will be subject to this new offence. So organisations based overseas could also be prosecuted where an employee or agent commits fraud under UK law or targets victims in the UK. So the intention really with the new offence is to make it easier to prosecute corporates for fraud, because there's no requirement to establish that senior management ordered or even knew about the fraud. And any organisation which is convicted of the offence will be facing a potentially unlimited fine. There is, by the way, currently no intention to prosecute individuals, so for example, directors, for failure to prevent fraud. The offence is purely targeted at those organisations themselves, although there are separate ways in which individuals could already be prosecuted for themselves committing or encouraging or assisting fraud. So I mentioned that a relevant body or organisation will be able to avoid prosecution or avoid conviction if it can demonstrate that it had reasonable procedures in place to prevent fraud, or in certain circumstances that it was reasonable for it not to have any prevention procedures in place. So, for example, the organisation is operating in an area where the risk of fraud is very low. So the government's going to publish some guidance on those reasonable procedures before the new offence comes into force. But that's probably all going to be similar to the requirements that companies hopefully are already familiar with in relation to anti-bribery measures under the Bribery Act 2010, where again companies are required to have adequate procedures in place to prevent bribery taking place. And then also, similarly, the requirement to have procedures to prevent the facilitation of tax evasion. So it isn't yet certain when the offence is going to come into force. Like I've said, it's been introduced via an amendment to an existing bill, which is still passing through Parliament and hasn't become law yet. But businesses that are in scope, so that satisfy that um, definition of what is large, may want to start thinking now about what their prevention procedures could look like. Um, as I say, most large organisations are probably already going to have some level of anti-fraud procedures in place, measures in relation to anti-bribery and corruption, anti-facilitation of tax evasion, which they may be able to adapt and extend in relation to fraud. But they are going to have to think about them very specifically in the context of fraud, and simply automatically applying the same measures might not be adequate, and they need to think about tailoring it to the specific risks that they face in their particular industry and business. But as I say, in due course, there is going to be some guidance from the government, and those anti fraud procedures that organisations are going to start developing will need to be assessed against that new statutory guidance once it's published, to ensure that they do meet that required reasonable standard. Okay, so something to look forward to there. And then finally, I mentioned that we just take a quick look at a case that highlights how companies that have more than one class of share can trip up if they don't get a required class consent. So, in particular, in this case, the High Court held that the conversion of preferred shares into ordinary shares in accordance with the provision in the company's articles of association, which already provided for automatic conversion of those shares in certain circumstances, the court said that actually that amounted to a variation or abrogation of the rights attached to those preferred shares. And as the requisite class consent for that variation or abrogation hadn't been obtained, then the conversion was actually invalid, void, and of no effect. So the company in this case was a medical and health technology company. And in January 2022, two investors subscribed £42 million for preferred shares in the company. So those preferred shares, as their name suggests, had various special rights attaching to them, including preferred payment of arrears of dividends and return of capital, plus a priority return in any distribution on liquidation, return of capital, or sale of shares amounting to a controlling interest. So they had rights which applied, if you like, in priority to the ordinary shares, and that's why they were called preferred shares. So the rights attached to those preferred shares were set out in the company's articles, and those articles also specified that all the preferred shares would automatically convert into ordinary shares on notice in writing from what was defined as an investor majority. So I'm going to call that the conversion provision. So automatic conversion if there's notice from an investor majority. And then the articles also had a separate provision which I'll call the class consent provision, which said that the special rights attached to any class of shares may only be varied or abrogated with written consent from the holders of more than 75% in nominal value of the issued shares of that particular class. So we've got those two separate provisions. We've got the conversion provision that says preferred shares automatically convert in certain circumstances. And then we've got a class consent provision, which says you can only vary rights with the required class consent. So, spooling forward from after the investment in January 2022, we get to May 2022, when various ordinary shareholders who together constituted that required investor majority signed a letter purporting to give notice to the company requiring the preferred shares to be converted into ordinary shares in accordance with that conversion provision in the articles. The company solicitors then wrote to the investors informing them that their shares had been converted into ordinary shares and that the company's register of members had been updated as a result. Now, perhaps unsurprisingly, the investors objected to the conversion of their preferred shares. They argued that the conversion amounted to a variation or abrogation of the special rights attached to those shares, and so it could only be done with consent from the holders of those preferred shares under the class consent provision. And since that consent hadn't been obtained, the investors said the purported conversion of their preferred shares was void. The company and the investor majority relied on the fact that the mechanism for automatic conversion was set out in the conversion provision. And effectively, what they said was, well, having agreed to that provision when they subscribed for their preferred shares, the investors couldn't now object to it. So what happened? Well, the judge agreed with the investors. He said that the conversion of the preferred ordinary shares into ordinary shares amounted to a variation or abrogation of the special rights attached to those shares. And this, the judge said, gave rise, inevitably perhaps, to what the judge said was a clear tension between the conversion provision, which said the conversion of the preferred shares happened automatically on the required notice being given, and then the class consent provision, which required a further consent from the preferred shareholders before the rights attached to those shares could be varied or abrogated by means of that conversion. So the judge said that this tension between those two provisions was a drafting error. And so he resolved that drafting error by implying into the conversion provision wording to the effect that the conversion of the preferred shares was subject to having first obtained the consent required under the class consent provision. So basically what the judge said was the class consent provision took precedent over the conversion provision. And since the requisite class consent hadn't been obtained, then the conversion of the preferred shares, which amounted, remember, to a variation or abrogation of the rights attached to those shares, was in fact invalid, void, and of no effect. So when this case came out, it was viewed, I think, rather surprisingly, if I'm honest, by practitioners, because the rights attached to the shares and the way in which those rights could be altered were set out in the Articles of Association negotiated between the parties with the assistance of their lawyers. And the Companies Act does say that the rights attached to a class of shares can be varied in accordance with provision in the company's articles. And generally, a shareholder is taken to have agreed to the provisions in the articles in existence when they subscribed for their shares. If they weren't happy with those provisions, then they could simply choose not to subscribe for their shares. So in this case, the provisions in the articles included the mechanism for the automatic conversion of the preferred shares on notice from an investor majority. And if the investors weren't happy with that, then rather than subsequently objecting, then perhaps they should just have not subscribed for their shares, or they should have attempted to negotiate some form of specific consent into the articles. But, like I say, the issue here, as far as the judge was concerned, was the conflict between the conversion provision and the class consent provision. And since that tension hadn't been resolved in the drafting of the articles, well, the court had to step in. So, probably to avoid a similar issue in the future, although we'll have to wait and see if this decision is appealed, which I believe it may be. But to avoid a similar issue, companies and their shareholders should ensure that the interaction between any conversion provision, or in fact, actually any other provision in the articles which could amount to a variation or abrogation of class rights, and then any class consent provision is expressly dealt with in the articles. So the articles should say whether the conversion or other provision requires class consent, or, in fact, whether the relevant class is deemed to have consented to the variation or abrogation of their rights in the way provided for in the relevant provision and without the need for any further consent. So there we go, some things for companies, for directors, and large organisations to think about in the future. Hope you found that interesting. Thank you for listening to Talking Business. To find out more about the series, please visit gatelyplc.com/talkingbusiness. From there, you can subscribe for all updates, meet our speakers, and get more information on all of the topics being discussed.